And welcome to our global engagement series entitled The Shifting Geopolitical Landscape and International Law in the Asia Pacific. My name is Matthew Erie, Associate Professor at the University of Oxford and the co-chair of the Asia Pacific Interest Group of the American Society of International Law. This global engagement series is part of the preview series, if you will, in the lead up to the annual meeting of the American Society of International Law. And for this particular webinar, we have been partnering with the Asian Society of International Law, and in particular, the Secretary General, Professor Tony Anghie, has been coordinating with us on this event. And if he is able to come in, I'm going to now turn it over to him for his remarks. Professor Anghie, over to you. It looks like he may have just dropped out, and that's unfortunate. I think he's trying to join again. But why don't we try to shift now to the moderator? I'm happy to introduce Professor Xianli Tan of the National University of Singapore Law Faculty. And Professor Tan can get us started, and maybe Professor Anghie can say a few comments once she's done with her welcoming remarks. Again, welcome everybody. Look forward to this event. Thank you.
Hello, everyone. Hello from Singapore. It is my great pleasure to introduce our three speakers today. So first we have Tan Sri Syed Hamid Albar, who is the former Foreign Minister of Malaysia and former Special Envoy to Myanmar for the Organization of Islamic Cooperation. And Tan Sri is now the Chancellor of Asia University. Our second speaker for today is Ms. Rehan Asad, who is a human rights lawyer, senior fellow at the Atlantic Council, and Tom and Andy Bernstein Fellow at Yale Law School. And our third speaker today is Professor Siddharth Malabarapu, who is a professor of international relations, especially focusing on India's outreach and geopolitical strategy at Shiv Nada University. Our fourth panelist, Professor Zhu Ying from Hong Kong, join us. So the sequence will be as follows. All the panelists I will pose some questions to the panelists, each in turn, and they will have about 10, maybe 12 minutes maximum to give their presentation, and then I'll move on to the next speaker. At the end of all the presentations, I will pose a general question to our panelists, and they will have a chance to conclude the session. To our audience, please type in your questions, any questions that you may have to our panelists, and we'll take them in turn to round up the session. So hopefully Professor Tony Anghie might want to join. Otherwise, Matthew, should we start or should we wait for Tony?
I think it's fine to go ahead and start the session proper. Then hopefully Professor Anghie can join us towards the end and maybe provide a few remarks. So why don't we go ahead?
Okay, great. Thanks so much. So Tan Sri, so just to start off our session, as a lawyer and former foreign minister for Malaysia, how much does international law factor into the strategic process of governments in the region, or for the government of Malaysia specifically, in terms of long-term strategic planning, especially in such turbulent geopolitical times, right? And also a second question, slightly different. As you served as a special envoy for Myanmar for the Organization of Islamic Cooperation, are such international organizations like the OIC and ASEAN constructive platforms for the international community to mitigate such tensions? Over to you, Tan Sri.
Thank you very much, Dr. Tan Xianli. And let me say that how honored I am to be part of this important, I think, discourse on a subject of great importance today, especially living in a very uncertain and unpredictable world of possible nuclear warfare that people are talking about today. And I think because of the time factor, what I'll try to do is that I will try to put all the points in terms of the paradigms. Yes, and then after that, if during question time, there will be questions, because I think otherwise, if I were to go into detail, it would be very difficult for me. And I think first, let me mention that as a newly independent country in 1957, definitely as member of the United Nations, we give a lot of importance to law, international law. The respect for the international rule of law is in order to create a stable international order that will benefit our national situation so that it can prevail. So I will just mention in your first question, how do you factor into the decision? I think the factoring of the decision of international law is in the fact that we want to see peace, order, and justice is achieved, so that we can participate effectively. And I think for smaller countries or middle power country, we have a different approach towards international law. Sometimes we look at international law is more in favor of the big powers or the bigger countries. But at the same time, we cannot do without it. It is for, we know our rights, duties, obligations, how we can interact with each other. When it comes to geopolitics, the smaller countries is at a disadvantage. Only the bigger countries there is. But it is still a factor of importance to us in terms of our strategy and long-term planning. So I think the most important criteria when I think in our strategic planning is that to see that whether our foreign policy will contribute toward peace, justice, and the common interest, and will serve ourselves as a nation that is interested in investment and trade. That is the first thing that we looked at. It's a framework which that allow us to know our rights and duties. How far? What are the limits? What are the strengths that to establish our position? So it is actually, if you ask that question, decision-making process, I think we recognize that it will facilitate mutually beneficial cooperation internationally as well as regionally. So, and then it will also help countries like ourselves. We must have a platform if there is any things that we are dissatisfied, or there are things that we think that should be brought up in order to have our voice heard. This, I think, the importance of international law, because it helps most vulnerable countries from abuse, oppression, and harm. And in this respect, I think it is the equality of sovereignty become important, the non-interference, non-intervention concept become important. So I think this is where the UN, I think, promote, because the UN promote economic, social development, and in advancing peace and security. It is a fundamental element in our decision making. But I will now go to so it is, as I mentioned, it's a fundamental basis of sovereignty and equality of all states. At least we don't feel disadvantaged in order for us to ensure that we are not living in a chaotic or because the international order, actually, when you look at the geopolitical situation, the international order is anarchic. There is no rule of enforcement. And the smaller countries, this is where the term of balancing, bandwagoning and hedging. So sometimes I think the bigger countries of our partners may not be able to see this, but may consider that it is trying to play safe. That it is actually a question of survival. So international law, whilst there may be criticisms of it, it is an issue of importance for our survival. So now I will go to the meat of what I'm going to say. I think insofar as foreign policy is concerned, it consists of broad levels of policy outputs. It's broad level policy output. I will borrow from our foreign affairs scholar, Johan Servamutu, when he divides the thing, he says that foreign policy outputs are objectives, postures, strategies, and actions. And these are the four important elements. When it comes to objective, it's the core values. And the core values in our case is that we want to have political independence. And international law protect us in getting that political independence and recognition of that political independence. And another one is territorial integrity. Our territorial integrity must not be interfered with in our national survival. In the case of Malaysia, all the time we are planning for settlement of disputes through negotiations, through engagement. And for that matter, our differences and conflict and territorial, like the Ligitan and Sipadan and Batu Putih, are all through ICJ. So that's how much we respect international law. We consider international law because we think that it will protect our core goals. International law will protect our core goals. Yes, I have complained about it, but I think it will protect our internet. The other thing that this is more, even though short term, it can result in long-term policy planning. This is on postures. We do have postures. Postures sometimes among the practitioners, we refer it to as is an or a general orientation of a state towards other world actors. You know, this is immediate and also I think, but it may require us subsequently to chart or map out long-term plans as a result. So together with our FP objectives, they determine FP strategy. The postures can determine the FP strategy and actions. So therefore, strategies and action may be more a function of foreign policy objectives rather than the postures. Postures may not directly result in foreign policy strategies and action. So I think we are playing sometime to the gallery. But you must remember that playing to the gallery in terms of, if you talk about shifting geopolitical landscape, like the Asia-Pacific, Indo-Pacific, ASEAN reaction to the Indo-Pacific is seen as non-committal and sort of thing. But I think that's how ASEAN has always been. We have got our ASEAN way, as you are very familiar, Professor. Our ASEAN way is sovereign equality. So when it's input, non-recourse to the use of force, this is under our Treaty of Amity and Cooperation in ASEAN, and then non-interference and non-intervention. And then the other thing that will relate to, because I'm starting with this so that when I answer the Myanmar one, it is the same thing. Non-involvement of ASEAN in bilateral conflict. ASEAN generally do not get involved in bilateral conflict. And then the other thing, again, I find that my Western colleagues sometimes question me. In our discourse or meetings, formal or informal, we tend to adopt the policy of quiet diplomacy in an open meeting. So, you know, this has got importance in terms of strategy and our ultimately how we make decisions. And the last part of it is mutual respect and tolerance. And there is a greater tolerance in our case in this of, you know, so that's what I want to say. And I now will touch before I go to the Myanmar one, is the on sources and content of Malaysia foreign policy. You know, the geopolitical, in terms of long-term planning, geopolitical is important. At the time of planning, we do not consider issue of law. After we have made that decisions, then we see how it fits in to the general framework of our citizenry in the international community. So that whether it is possible, it's doable or not doable. And this is our external sources. And sometimes we look into the eco-historical sources of it, or some people say that our long-term planning, sometimes it does involve idiosyncratic or elite sources, because the policy makers are usually very few. And I do not believe in idiosyncrasy, but I tend to look at the most important element in long-term policy is your national interest. Whether it serves your national interest, it doesn't serve your national interest. And that national interest must be fit in very well with the issue of you being a member of the international community and respect for the rule of law at an international level. We cannot be talking about rule of law only at the domestic level, but regional as well. So
so you will have about a minute and a half left to,
okay, I would
wrap
have
up.
a minute and a half. I would try to summarize. You see, when it comes, I was a special envoy for Myanmar. You know, international organizations can be saying irritant, annoyance, talk shop, but it is a necessary platform for us to be involved in discussion to resolve issues, even though it may take a long time. In the case of Myanmar, very difficult to find a solution. We have done the 5-point consensus, but still there is no decision. But imagine if there is no platform at all. There is no regional body. There is no United Nations. There is no WTO. I think the world will be a worse place. So I think the respect for international law on all our planning is very much dependent on the rule base, depending on rights and duties that are clearly spelled out. And this is done through international or regional law that will help us to mutually benefit from what our participation in the organization or in the United Nations. Thank you very much, Professor. Sorry to take the time.
No, thank you very much, Tan Sri, for sharing your insights, because I think what goes on, in high-level government policy planning and strategy is really opaque to the rest of us. And it's also very helpful for the rest of the world to know that, what you shared on quiet diplomacy on ASEAN, yes, on the surface, we may seem to do very little and always profess non-interference. But as we all know, Malaysia, Indonesia, Singapore have actually pursued, peace on the Myanmar front, but it is very, very, very difficult. And at the regional platform of the ASEAN 5-point consensus, we are deadlocked as to what to do. So thank you very much, Tan Sri. And now we move over to Ms. Rehan Asad. Rehan, good evening to you in DC. So your two questions. Regarding the international human rights system and the crisis in Xinjiang, how has the international community reacted to this situation? And because there is so much news out there, how does the international community differentiate between objective data sources and propaganda or fake news, right? And as a follow-up question, which is a broader one, given the state of women's rights in more restrictive societies like Iran and Afghanistan, and also the situation of ethnic religious minorities like the Rohingya and the Uyghurs, and wider LGBT interests throughout the Asia-Pacific region, how does Asia-Pacific look like in terms of, the new theater of human rights struggles? Rehan.
Hi, thank you so much for having me. Actually, earlier today, I went to an art installation called Ungreeable Lives, which comprised 13 children's dresses handmade from refugee life jackets gathered by an artist named Caroline Brewer. And in response to the migrant crisis with a composer named Charles Bray. And as I was watching this art installation, what calls to mind is many victims of state violence and atrocity crime that, as you mentioned, who are disappeared. And one example of this is the Uyghur people in China, who have disappeared in the shadows of the Chinese vast concentration camps. from the forced labor camps to concentration camps and enforced disappearance of Uyghurs, cultural and resource dispossession, sexual abuse, forced marriages, and forcible transfer of children, all of which that is happening to the Uyghurs in China is one of the most well-documented atrocity crimes, not just by civil society, but also the regime itself. It is a big bureaucracy. As a result, in order to instruct the prison guards and everybody from the top down to enforce these kind of genocidal campaign, what China relied on is a manual and government speeches and all these sort of mandates to continue its atrocities. So it's very easy to discern what is the truth and what is the propaganda. And I think we need to be very careful in terms of not re-victimizing the victims because it took years for the civil society and as well as many courageous survivors to tell what's happening to the Uyghur community. And we're not even considering the trauma of geographical dislocation and cultural dispossession on the Uyghurs who have been enduring and continue to endure state violence. So I caution that. And the other dimension is that China is very successfully using disinformation and propaganda to present this Potemkin villages of Xinjiang and presenting Uyghurs are living happily. And I'll get into that from another discussion that I had with an ambassador from African bloc. And if these ambassadors can discern the truth from the propaganda, I think those of us within the human rights community, I think we need to be even more vigilant. I do feel like, examining the mass atrocities against the Uyghurs as a lawyer and as a member of the Uyghur community, feel like assessing international law, because every aspect of this crisis touches on a very specific international law or norms, whether corporate accountability or the lack of jurisdictional response from the ICC and as such. But this campaign against the Uyghur is in no doubt violates many international conventions, including the international and including the Universal Declaration of Human Rights, and as well as the International Convention on the Elimination of All Forms of Racial Discrimination, Convention Against Torture and other cruel, inhumane, or degrading treatment or punishment, all of which China has ratified. And unsurprisingly, the campaign obviously violates Chinese constitution, which itself doesn't endorse genocide per se. In fact, over the past few years, China has passed more laws. Some appeared to be, at least on the face of it, more legitimate. Others appeared, especially the white papers in relation to these concentration camps, offered justification and a framework for its re-education camps to further institutionalize and legalize the vast prison camps the world has seen since World War II. I do have a report coming out, and I hope it would not only illuminate the truth, but adds really credible voice to the ongoing documentation of the Uyghur atrocities. And how did the international community respond? And as I said, I think the civil society response has been robust, given the magnitude of crisis, and it took some painstaking years to document the ongoing atrocities. And I, as a Uyghur lawyer, and as well as in some ways, one might call as a secondary victim, given no Uyghur family could escape from the ongoing atrocity, was the first one to call for genocide determination, along with my co-author, Yona Diamond, in our foreign policy article, which was dubbed as the top foreign policy paper of the year. I did feel like after that article, there was a lot of discussion in terms of labeling of the Uyghur atrocities. While labeling does matter, I felt like there was a point, it was very much unjust to trivialize the unimaginable suffering of my own community. And the reason why we push for atrocity determination, especially genocide determination, not only the every act committed in the camps meet the UN definition of genocide, but also international law imposes an obligation upon states to prevent and punish genocide as soon as becoming aware of serious risk of genocide. From the US Holocaust Museum to many governments did realize that and actually made an atrocity determination. But in terms of, was there like strong political will to prevent and deter atrocity? That is very much debatable issue, because other than imposing sanctions here and there, we haven't seen a robust international response. And I do say that international community has failed and continues to fail the Uyghur community. I think one thing that we need to bear in mind is that international community's responsibility to protect is triggered by the evidence relating to crimes against humanity and serious risk of genocide that was so powerfully presented by not only the survivors' accounts, but also the mapping of the camps which used modern technologies, satellite images, and so forth. So and in those discussions, I felt like that it really obscured what matters the most. And in this case, the Uyghur people, and what I wouldn't just put them as victims and take away their agency and resilience, but also right holders. For more than anything, what the Uyghur community needed was an international, robust, and urgent support, as what's happening is beyond imagination of human beings. Like a very superpower had brought back the concentration camps with impunity. I think what the Uyghur issue tested is the fundamental flaws in the human rights system, where unless it involved the security dilemma, I think international series talk a lot about this, and I see this whether it's at Oxford or at Yale Jackson. And we also saw much of it in the current Ukraine crisis as well. Countries would prioritize their trade and business interests and be willing to look away. Effective prevention action has not been triggered in this crisis for the 7th year. And another dimension of this is the corporate accountability. We saw massive corporate complicity in the Uyghur crisis. And in fact, just yesterday in the Wall Street Journal, despite the several laws that passed to curtail Uyghur forced labor, there has been continuous increase in the foreign investment in China. Many companies, including Starbucks and Volkswagen, many other companies, especially some in the Ralph Lauren in the textile industry, is going to expand their operation in China. And that feels like very demoralizing, because it took us years after effectively advocating to pass these laws, which I thought it's a past-breaking legislation that would really change the entire anti-slavery movement. And it's important to point out that there are no avenues for fair and independent and impartial adjudication of these egregious human rights violations within China. And obviously there are also many limitations to hold the Chinese government accountable in independent forum. Finally, we had Uyghur Tribunal Civil Society convened hearing by Sir Jeffrey Nice, which is commissioned by the Uyghur group, and the Chinese government very quickly dismissed that as it's not a UN mandated tribunal. We also saw massive support for other people's court hearings from other nation states, but for this particular one, again, we didn't see support from many states, sovereign state, and all of which is dictated by China's economic might and shift in the geopolitical balance, as the title so aptly suggests. It took years of and a lot of pressure for the civil society to make sure the OSCHR to issue the Uyghur report. Ultimately, it came out pretty strong and robust and accused China of committing an international crime, in particular crimes against humanity. And I want to add one more thing, which is the two Uyghur groups filed like a landmark case in the International Criminal Court following the illegal precedent set forth by the Rohingya group on the theory of mass deportation, which amounts to crimes against humanity. The case was a true test for the International Criminal Court, as whether it would be willing to hold powerful states equally accountable as smaller states. And so far, we haven't seen any progress on the case as well. In my recent conversation with one of the ambassadors from African bloc, and I'm not going to name the specific country.
Excuse me, Rehan, could you wrap up, because we
yes,
would have to.
For sure.
Yes, thank you.
Yeah, I think I asked the ambassador whether this country would be willing to step up to support the Uyghurs, and the response I got is like, please push us more. And just to conclude, I think not only the Uyghurs, besides China, several countries in the Asia Pacific also descended into full-blown human rights crisis in the past few years. And I think as time permits that I would be more delve into those discussions, especially involving women in Afghanistan, as well as the Hazara community who's facing ethnic cleansing and the risks that human rights defenders facing, and how COVID actually further marginalized many already disenfranchised communities. Thank you.
Thank you very much, Ms. Rehan Asad. I think you have tied, the factual situation, the sources, the actions, or maybe the inaction of the international community, and how civil society groups have moved forward, and also the rise of people's tribunals regarding the entire situation. So thank you very much for your presentation, and also illuminating us on the wider systemic aspects of the human rights situation. So now we turn to our final speaker, Professor Siddharth Malavarapu, who will talk to us. So Professor, you come from India, you're now in India very early morning. So India seems to be one of the beneficiaries of the current, ongoing US-China trade war. So global supply chains are now being rerouted to India through, the COVID pandemic, especially now with the turbulent geopolitical situation. So with India's, rise and also a populous young generation, how do you anticipate that the rise of India will impact regional order and the economy? A second question is regarding international law, right? So India has been criticized for not prioritizing international law in its foreign policy, foreign strategy, and also in multilateral institutions. So how do you see India taking international law more seriously in its foreign relations, and also to be a regional leader in protecting, enforcing, and strengthening the rule of law in the Indo-Pacific? Thank you.
Thank you. At the outset, my gratitude to the Asian Society of International Law and the American Society of International Law for having invited me to be a part of this panel. I would also like to tip my hat to Professor Tony Angie and Professor B.S. Chimney in particular for their influence on my approach, particularly a curiosity relating to anti-colonial internationalisms and the implications for reimagining international law, as also the manifold implications of politics and its relationship with international law. A brief disclaimer, I come to the subject from a disciplinary grounding in international relations, with an active research inclination to pursue how politics impinges on international law. In the next few minutes, I wish to address the two broad questions Professor Tan just posed. First, I ask, employing Rahul Sagar's phraseology in a journal article published in International Affairs in 2009, titled, "What kind of power will India become?" And that's a question which I think I'm interested in addressing both geopolitically, but also I think the latter question relates to attitudes and practices of India vis-a-vis international law. Let me begin by addressing the first question. First, I would like to state the significance of geopolitics in the region as critical for India's rise. I think it's quite clear when we look around today at the world, there seems to be at least a feeling, an uncanny feeling that there is a slide towards old-style geopolitics, classical geopolitics in some senses. Of course, this is only a part of the story, but I think what is important here to recognize, as some scholars who are working particularly on global supply chains, like Amitendu Palit in the Indian context, have suggested, is that what we witness here is that geopolitics seems to be privileged and seems to, in a sense, matter much more than even other rationales, such as an economic logic in some instances. So there is a constant quest, of course, for allies in international relations. There is a constant quest to think about ways in which states can bolster their presence within the international system. And I think India, in that respect, is not very different from many other states in terms of its desire, at least to play a more significant role in the international system, while, of course, taking care of its perceived national interests. In this context, I think the global supply chains issue does provide an opportunity for India, in a sense, considering that there is this sense of the competition between the United States, one would treat as a status quoist power, and China, in some sense, as a revisionist power at this particular juncture in history. I think there is also the question here of how we can think about possibilities within India of becoming a sort of a serious manufacturing hub. I think there is a lot of emphasis within official discourse on being a manufacturing hub. There is a very popular, iteration of it in the Make in India understanding at this point in time. And considering that this is a large economy, I think the emphasis is clearly and a recognition today that there is a need to sort of perhaps take this opportunity to increase and step up on the manufacturing pedal in order to really contribute to these global supply chains. But having said this, there are also a number of challenges which we face in the context we are operating in. I think we're still fresh from the Hindenburg report, and there are serious concerns about one, of course, I think there are concerns about accountability and sort of the systematization of accountability when it comes to businesses. I think there is an interesting account I read of Aswat Damodaran, a professor of finance, who argues, a professor of finance at NYU, suggests that one of the issues which I think India will have to contend with in the years to come is this whole issue of transparency when it comes to business practices as well. And the litmus test for this is really not going to be so much regulations on paper, but much more to do with actual actions on the ground. So I think there are some challenges in this domain. There is a need, therefore, for an accent on stronger fundamentals. I think there are two other elements in the Indian understanding of what it should do in order to matter more economically in the world today. And one, of course, is this emphasis on renewables, but there's also an emphasis very often on digital technologies. I think both these aspects seem to be important as far as economic priorities within are concerned. But having said this, what are the implications of all of this as far as the region are concerned? At the moment, South Asia still is among the least integrated regions of the world. And the hope is, of course, that a rising India will eventually be able to provide more for the region. Strategic commentators in this part of the world very often use the term positive unilateralism. And what they mean by that is that as a larger power in the region, India will be expected to be more generous when it comes to its regional neighbors in the South Asian context, in the more immediate South Asian context in particular. What we've also witnessed quite clearly are that broader arrangements like SARC have belied expectations, and therefore there is need to think about other forms and other forums in which there are possibilities for building on elements of regional integration. With regard to a second dimension, I think India will have to skill its growing population if it has to really allow for a demographic dividend both in the short and in the long term. We need a younger population which needs to be more skilled. There is a lot of apprehension in the Indian context today about AI and the loss of jobs in the absence of globally competitive skills. And I think quite clearly one will witness more of this emphasis in the years to come. But this again remains a significant challenge. And third, in relation to the question of how this impacts potentially on the region, I think what we will witness is that domestic politics will shape attitudes of other states in the region to India. And I would flag two realms which are of particular significance here. One, of course, relates to India's overall diversity commitments, and the second aspect relates to how well we fare in terms of strengthening our democratic credentials. And I think both of these will be watched closely and will have a bearing on how we perceived both this in our immediate region, but in the wider world as well. I think there are now. If I turn my attention to the second question, I think it's untrue to claim that India has had a poor history of engaging with international law. I think there is a lot of work to suggest that there has been an engagement with international law, which has, I think, in the context of Professor Tony Angi's work, quite clearly the interest in various forms of anti-colonial internationalisms. I think it's something which clearly merits attention, whether it was the history of the Bandung or the New International Economic Order, or if you think of UNCTAD as well. I think quite clearly in this context, there was an attempt to engage with the world in very significant sorts of ways. But I think the broader question about ambivalence, I think, which was also posed by one of our distinguished preceding speakers, is something India also contends with. And when we think about ambivalence, we can think about it in two idioms. One, I think, with regard to the fact that international law sometimes is viewed as calcifying privilege, and on other occasions can also be seen as a vehicle to empower the weak. I think both these possibilities are also very much something which is sort of part of the Indian thinking around international law. I think I do not wish to get into doctrinal debates here, given the paucity of time, but scholars like Prabhash Ranjan in the Indian context have noted that there's a shift from dualism to monism in the manner of interpretation of international law by the Indian Supreme Court. There's also work, of course, which points towards what Lavanya Rajamani refers to as a selective internalization and aspects relating to how we instrumentalize aspects of international law in the Indian context. I think there are some fundamental challenges when we think about the whole question of moving forward and how India will relate to international law. I think the big elephant in the room at the moment, clearly, and for some time now, has been the Indian response to the Russia-Ukraine war. Quite clearly, I think it's a blatant transgression of international law when we look at what has transpired. But while not indifferent to Ukrainian hardships, I think there has been also in the Indian context, as one Minister of State, former Minister of State of External Affairs has noted, a certain reluctance to characterize, Shashi Tharoor has noted that there's a certain reluctance to characterize the current episode, the ongoing episode, as a war, and the terms conflict and crisis are used much more often. So there is this whole question of strategic autonomy, but there is also a tension between what some might treat as a more classic geopolitical stance, which is really looking at a set of national interests in the context of dependence on Russia's defense and maintenance of our defense equipment, and a broader tension between a commitment to principles such as the principle of non-intervention in this context, but also broader UN Charter principles. I think India has reassured the world at various points in time that it's very committed to UN Charter principles. But I think there are a number of issues which might help goad us in the direction of moving to at least critically reassessing aspects of international law in the Indian context. One, I think there has to be an acknowledgement of higher stakes in the shaping of the international legal order. I think there has to be, within the Indian context, at least there is a sense that there has to be greater confidence in the fairness of international law and its application. I think in the past, India has been keen to sort of bandwagon with, with countries within the global south. And I think there has to be, even today, if one thinks about it, a willingness to continue to take on at least aspects of this consolidating solidarities within the global south. I think international law also becomes important when you tether it with a desire for countries like India to have a more respectable role in international organizations. And quite clearly, there are democratic deficits, both in the manner in which international organizations are currently set up and configured. And I think this also reflects sometimes in the manner in which international law itself comes to matter in certain regards. And I think for post-colonial states in general, I think there has been this constant emphasis on, or a concern that international law should not in any way jeopardize its own domestic sovereignty. And I think this continues in various forms. I think what countries like India will also be looking at is the broader record of compliance or non-compliance by the major powers of international law provisions. And finally, I think there is this aspect of trying to, I think within the Indian context, the need to foster a better appreciation of the value and purpose of international law. And I think there's here a scope for a lot of homework, in terms of, further strengthening on those or building on those dimensions. So this is just a broad sense of, I think, what are some of the elements in the Indian makeup as we see it at this point in time of international law, as also the earlier question on global supply chains. There are opportunities, but there are also challenges which lie ahead. Thank you.
Okay, thank you very much, Professor Siddharth. That was a very comprehensive and also very rich insight as to how India perceives and how India projects and how India conceives, the utility and also the fairness and the democratic deficit of international law with regards to its role. Thank you so much. We have some time, about 5 minutes for questions and answers. So opening this discussion up to the audience, if you have any questions, could you please type them into the chat box? Otherwise, we will have the final question to all the panelists. So Ms. Rehan Asad, Tan Sri Hamid Alba, would you like to come back on?
The attendees should type their questions into the Q&A box, not the chat.
Oh, the Q&A box, sorry, rather
okay.
than the chat box. Thank you, James. Tan Sri, are you there?
Yeah.
Oh, hi. So maybe there are no questions from the audience. So let's go on to our final question to all of you, all three of you. So, we have talked on a huge range of international issues and the tensions that the international order faces, and with regards to the Asia Pacific. So as your concluding comment, how do you see and how do you wish international law to respond to these challenges that we have discussed? So perhaps we can take it in turn. Tan Sri, would you like to go first?
Okay. Thank you very much for the opportunity. I think I've been very much enriched by listening to all the other distinguished speakers. But let me say that I would like to see as a question coming from this part of the world, that international law can be more accountable and transparent in its application. At present, there is a gap between the theoretical, conceptual to the practical part of it. Somehow or other, the smaller countries or the middle power countries feel that international law is not embracing diversity, not protecting them enough. We tend to establish, we want to establish standards, but those standards, of course, we talked just now, I think Professor mentioned about monoism or dualism. But I think most important, like in the case of Malaysia, we have accepted in our courts that international law is part of our law. But in that case, we must feel that international law can protect us. And I think international law, what is lacking, I hope, in my conclusion, I would like to say, is yes, I think in terms of values, in terms of norms, have set very good values, very good norms, but in terms of its application and enforcement, there is where we need to focus our attention. Thank you very much.
Thank you, Tan Sri. And Ms. Rehan?
Well, I'd say that despite the human rights abuses that I mentioned concerning not just the Uyghurs, including Hazara, Afghan women, and as well as Rohingya community, in Asia, we also saw incredible human resilience and mass mobilization of human rights movement, from Mukti Alliance, which is a powerful movement of groups gathering together in shared solidarity. So I would say it's very important for each one of us within the international community to show our support for all these human rights movements, including by considering entertaining all sorts of possibilities about targeted sanctions. From the international perspectives, for the Uyghur issue, I would say that despite the China reserve its right under the Genocide Convention, any sort of accountability and measures, I would argue that by signing onto a convention that prevents and deters atrocity crime, there is this implicit consent to be bound by any sort of accountability. But for it to happen, for us to even stretch the boundaries of the international law, what we need is a willing state to take up the Uyghur cause. So I really hope that lawyers within all these countries, like, we need to galvanize our government support to be a responsible stakeholder and make sure that universality of international law is applicable to all oppressed community. We cannot pick and choose. And secondly, there's a case in Argentina under the theory of universal jurisdiction, given that regardless of the label of crimes against humanity or genocide, these are jus cogens norms that what China committed against the Uyghurs is a very heinous crime. I hope that more countries would allow their universal jurisdictions for the Uyghurs to bring cases, and not to reject the plight of the Uyghurs because of their prioritization of geopolitical interests and as well as trade and business interests. Those are the kinds of immediate things that I wish to see to end this ongoing atrocity.
Thank you very much, Ms. Rehan. And Professor Siddharth?
Right. Yeah, I would think again that, there is a tension between theory and practice. And I think there is two elements which perhaps would be very important especially for countries in the global south, examining the various elements of international law. I think one, of course, is consistency in terms of the application of the principles of international law. And the second aspect relates to, I think, a concern sometimes about double standards and exceptions, which very often are invoked in certain circumstances. I think there is concern about that. I think also one of the elements which I did flag earlier, I think, was about the reform of international institutions. And I do think that both international law and international institutions can't really be separated beyond a point. I think we need to think about elements in which a reform of one also impinges on the reform of the other. And I think that aspect and that twinning at some level is important for to have a much more inclusive and balanced notion and understanding of international law, and then its subsequent internalization within various countries of the global south. Thank you. Yeah.
Thank you very much, Professor Siddharth. So I think from the discussion generated by all our three panelists and also their wish for international law is about transparency, inclusivity, plurality, and also the participation of smaller actors, smaller states, smaller powers, so that there can be a real protection of the international community, as it were, by international law. So I think that's a very profound statement or profound expression, especially because, well, India is a large power, right? But the rest of us come from smaller regions, smaller powers, and we would like to participate in the international legal order with probably more democracy and more fairness, so to speak. There is just a couple more minutes. So any questions? Oh, I think I see a question. Yes, so Mr. Daniel Mandel has this question. So Russia has prevented the UN Security Council from acting on Ukraine. China has refused to follow the international court's ruling on the South China Sea, and the US has prevented the WTO's appellate body from functioning. So a question to the panelists, and I guess perhaps more to Tan Sri, is that what do the countries in Southeast Asia or developing and smaller states more broadly, what do we think, smaller states, think about what seems to be the failure of international law in such cases? And what can we do when the international legal system is not able to resolve a problem because of a large power? So,
can I say something? I think what is most important, I find that we tend to focus on the issue of law. I think it is better for us to look also in terms of its application on the issue of justice. What the smaller countries feel is that there is lack of justice, there is double standards, there is selectivity. So now we are seeing the Ukraine situation, we are seeing the South China Sea situation and all other things. In the Myanmar situation, there is genocide, there is crime against humanity, and nothing can be done. I think this is and I think here, the international lawyers community can do more in order to ensure that there is something that can be delivered to I think, create the confidence that it is there to protect everyone, every nation, every state. So the minorities feel protected. There is inclusiveness, as mentioned by you, Professor. I think we must make sure that there is justice at the end of the law, not just simply law as a rules and regulations. Thank you.
Okay, thank you very much, Tan Sri. Ms. Rehan or Professor Siddharth, do you have anything to add?
Rehan, would you like to go first?
Why don't you go first?
No, I think I would entirely concur with what was just said about law being tethered to notions of justice. And I think we need to ask ourselves what notions of justice, are widely acceptable and desirable, especially for those who've historically been somewhat more marginalized within international law. And I think that question still remains, and I think it's important to find ways in which we can have that conversation. The other issue I would think, which is important, is also to think about the relationship between international law and politics and more generally. I think there's a temptation sometimes to sort of really erect that fiction that they're entirely, independent. They are to a large extent. I think the effort, at least, is sometimes to clearly make a distinction between what is legal and what is political. But I think the permeability or the sort of seepage very often of politics in shaping various aspects of the edifice of international law is something which we need to have a more honest conversation about as well. Thank you.
Thank you, Professor. And Ms. Rehan?
I actually very much liked earlier discussion about decolonization of international law, because Asia is such a broad context. Like every country has its unique dimension. First and foremost, we need to understand that, and oftentimes, some view that these human rights, these norms are Western imposed ideas on Asian countries. They have very different culture. But if anything, including the recent protests in China, the wide range of protests in relation to the zero COVID control shows that people's aspiration for the universal values of human rights. So I think it's a very important that first and foremost for the international community to engage in their own decolonization and respect people's aspiration for the universal values of human rights. Second, I also feel like oftentimes, when issues concerning the spy balloon of China, which is about security dilemma, those kind of issues gets much more media attention than the atrocity crimes itself. So we need to really activate many stakeholders, including making sure media continues to exercise its oversight. We need to invite more institutions into the discussion. I've seen a lot of complicity from not only these corporations, but also universities too, in terms of academic freedom. Perhaps law school is a very unique wing in terms of academic freedom, but schools like public policy or international affairs, which very much focus on international security, rightfully so, I understand that, but incorporating human rights into the discussion has to be very important aspect of school teaching. And I think only by doing that, we can then make sure that the policy and international law do match. And because without these two, they have to marry each other to have a robust response to atrocity crimes.
Thank you very much, Ms. Rehan. So thank you very much to all our three panelists. You have really taught us a lot. And I would like to conclude this panel thanking the audience and also our sponsors, the American Society of International Law, especially the Asia Pacific Interest Group, and also the support of the Asian Society of International Law. So thank you very much, everyone who has joined in. Good evening, a restful night, and those in Asia Pacific, a very good day ahead for all of you. Thank you so much.
Thank you.